I'm Eve Hill, as you know. I am a disability civil rights lawyer, and I've been doing disability civil rights for about 32 years. So since pretty close to when the ADA was enacted. And I've been doing digital accessibility for almost that long, because back in 1996, I helped write a letter, which has been cited in court many times, telling a congressperson that the ADA applied to websites and other digital technologies. So we knew way back then that the ADA was not limited to the things that it specifically called out, but that it applied to the digital communications of covered entities. So I usually start out by talking a little bit about, okay, next slide. What is digital accessibility? Excuse me. And you already know this. Next slide. And I've stolen this from Lainey Feingold. So I have very good predecessors in almost everything I do, and Lainey is one of them. Digital accessibility is the bridge to everything: information, services, goods. It connects customers and constituents to the entities that are putting out the websites. So you all are bridge builders. Next slide. And it is a doorway to customers and constituents. It allows customers, taxpayers, students, patients, everybody to participate in the services and activities that businesses and government entities are offering. 16% of the world population, or 1.3 billion people, have disabilities. And that amounts to $3 trillion in disposable income worldwide. We don't want to leave out this population. So you are the door openers to customers and constituents. But this is my favorite slide. Digital accessibility is a civil and human right. It means equality, it means privacy and independence, it means participation, communication, education, health, safety, and so much more. And digital inaccessibility excludes people with disabilities from society, so much of which is digital now. So you all are, like me, civil rights advocates. Welcome to the civil rights movement. Now, this is no joke. Digital accessibility is one of the key civil rights movements of our time. If we don't get this right, we leave out millions and millions and millions of people across the world. By doing what you all do and what I try to do, we are bringing in those people. We are bringing in the people who are excluded. And you are part of that movement. We are also faced with a federal administration, you may not have noticed, that is openly hostile to civil rights, possibly including disability rights. We're not entirely sure how hostile they are to disability rights, but at best, they're not going to help. So we are part of the resistance to the dismantling of disability civil rights across the country. Next slide. So what is digital accessibility? You know this better than I do, but it's intentional practices that make inclusion happen. It's born accessible. The goal is for people with disabilities to be able to access the same information, engage in the same interactions, communicate and be understood effectively, enjoy the same services with the same privacy and independence and ease of use as people without disabilities. And that definition comes from my colleague Dan Goldstein, which is now used in settlements and guidance and everything from the Department of Justice. And that's what we mean by digital accessibility. Same for people with disabilities. Next slide. Now we'll do the legal updates. Not much going on. Totally boring. I got nothing to do. So the current requirement under Title II and Title III of the Americans with Disabilities Act is equally effective communication. You have to ensure that covered entities have to ensure, next slide please, that their communications to and from people with disabilities are as effective as their communications with people without disabilities. They do that by providing auxiliary aids and services, and auxiliary aids and services include accessible electronic and information technology. And in order to be effective, those aids have to be accessible, timely, and protect the privacy and independence of individual with a disability. But they don't provide a technical accessibility standard. So I tell companies and state and local government entities, that gives you flexibility. If you can find a standard or a way to make your stuff equally accessible, you can use it. I happen to know that the only standard out there is the Web Content Accessibility Guidelines 2.0, 2.1, 2.2. But there's no technical accessibility standard. If a covered entity provides information or receives information, it must make sure that information can be received and given to people with disabilities equally. And DOJ, other federal agencies, Section 508 of the Rehabilitation Act, and courts have all said, if you comply with WCAG 2.0 or 2.1, level AA, you meet the effective communication standard. So there may be other standards or other ways of meeting the standard, but we know that WCAG 2.0 or 2.1 meets the standard. Yay us. Next slide. But now we have a new Title II web regulation from the Department of Justice applying to state and local governments. And it goes into effect April 24, 2026 for entities with 50,000 or more population, and April 26, 2027 for entities with population fewer than 50,000. So smaller entities get more time. But population is determined not by the number of students at your school or the number of patients at your hospital. It's determined by the census data on the entity that you're a part of. If you're a state school, your state is the number that you'll determine your population by. So that's an important point. Be careful when you decide what your deadline is. Next slide. So this gives a standard. Title II entities, state and local government entities have to meet WCAG 2.1 level AA. But there's still some flexibility. You can meet an equivalent facilitation standard, meaning you achieve the same thing, you do it a different way. That's fine. And it covers all web content and mobile apps the public entity makes available directly or through contract, licensing, or other arrangement. So it's not just the stuff the entity does itself, it's the stuff it pays or uses or arranges with other entities to provide. Next slide. Oh, cool. I just got the slides on my screen here. Okay, there are 5 exceptions to the Title II rule. So this is a little weird. The current requirement says equally effective communication of everything you communicate. The new reg gives you a little less flexibility because it gives you a standard, but it gives you a bunch of exceptions so that not everything has to be accessible. So right now, arguably, everything has to be accessible. Boy, are we in trouble. In 2 years or a year, in a year and 2 years, depending on the size of the entity, there'll be some exceptions. Exceptions don't have to be accessible in advance, but they have to be made accessible on request. So best to be prepared for those requests as well. The first exception is archived web content. Archives have to be created before the effective date. Everything after the effective date has to be made accessible from the beginning. But if you have stuff before the effective date that's not accessible, you can archive it, but it has to be kept only for reference, research, or record keeping. If you're using it in any way, it can't be an archive. It has to be in a special area for archive stuff, and it can't be changed since it was archived. And you still have to make it accessible on request. Next slide. Oh, by not talking nearly fast enough. Thank you. So another exception, 2 other exceptions that are related, third-party posts. Often state and local governments will provide forums for people to post their own comments or to submit comments on their regulations or on other actions that they're planning to do. Those third-party posts don't need to be accessible, as long as you're not arranging with those people to post through a contract, licensing, or other arrangement. And the third-party content that the public entity posts is not exempted. So for example, some state or local governments mostly use GIS data ARC maps, they call them, where they show all the zoning. You can see the zoning of the area. You can see other aspects of the area, where the water is, where the floodplains are. They're doing that through an arrangement. It's a third-party post on their website, but they're doing it through an arrangement with that provider. That's going to have to be accessible. And the tools or platforms that allow people to post have to be accessible. So you have to give people the tools to make their posts accessible. Then pre-existing social media posts don't have to be accessible. You've already been posting on Facebook or Twitter, or no, it's not called that anymore. I refuse to say the new name. Or whatever social media post you're using now. If they're posted before the compliance date, you're not required to ensure that they're accessible. But you must use any accessibility tools that the platform makes available. Next slide. And then the final two exceptions are individualized password protected documents. For example, you send electronically people's tax bills. It's password protected. It's only to that person. It's about their property. So those are all kinds of documents, word processing, PDF, spreadsheets, but they have to be about a specific person, property, or account, and they have to be password protected. Note again, you don't have to make these all accessible, but when the blind person says, I need my bill accessible, you have to be prepared to provide it in an accessible format. And then this is the big one, pre-existing conventional electronic documents. This is mostly PDFs because Word's so easy. They have to be on the website before the compliance date and not currently being used. If you have to use the PDF to access your services, it's not accepted. You have to make it accessible in advance. Next slide. Okay, some things that DOJ thought about accepting, and we, the disability community, pushed back hard and successfully. Yes. So password protected course materials or educational technologies are not accepted. If you're providing course materials to your students, even if the student needs a password to access them, they are not accepted. We argued, and correctly, that this would have swallowed the rule for education. It would have made everything exempt. They did not exempt captioning for live audio content. That is a recognition of how far we've come with live audio captioning. As you can see, it does not exempt linked third-party content if the public entity makes the content available through contractual licensing or other arrangements. They thought about accepting any linked third-party content, but we pointed out that ArcGIS, the zoning map, the floodplain map, all those things are something that the entity is offering. They're just using a third party to offer it, and those should not be exempted. They didn't exempt external apps that the public entity uses through contractual licensing or other arrangements. Think of this as Park Mobile or whatever parking app, there are a gazillion of them, that your jurisdiction uses, but mine uses Park Mobile. You pay for on-street parking using this app. They are offering it. The city is offering it. That has to be accessible. I'm sure Park Mobile will be shocked. It didn't exempt library digital materials. So libraries, the source, the fonts of all information will be accessible. And I really cannot wait for that day. And it doesn't exempt classes or activities without participants with disabilities. So the town that says, we don't have any of those people here, too bad. We're moving in, we're coming, and we want our stuff to be accessible. Next slide. Okay, you still have some defenses. Pretty much the same defenses that we already have. The entity has a defense if they can demonstrate that the nonconformance has such a minimal impact on access that basically no one would notice it. So that's often going to be a purely decorative image. The logo, maybe, although I think logos are interesting, so we could argue about that. But something they can say really doesn't affect the accessibility of the website. It's so minor. We have the existing defenses of undue burden that is so hard to do that you can't do it within all the resources you have available. So states are going to have a hard time asserting an undue burden defense. And one of the reasons they always have a hard time, I'm fighting about this with the state right now, is they forget to write it down. You're supposed to write it down at the time you determine it's an undue burden. Defenses are not self-executing, and you don't get to make it up afterwards. You have to write it down at the time. We thought about this and we can't do it, and here's why, and keep that in a drawer to show me when I get to you. And then fundamental alteration. This would so interfere with the fundamental purpose of this program that we can't do it. Again, that has to be documented in writing from the beginning. And if any of these defenses apply, the entity still has to provide an alternative aid that wouldn't be an undue burden. So you got to go as far as you can. So you can't just say, well, we're not doing anything. You got to do what you can do. Next slide. Okay, there's a little DOJ guidance here. You will get these materials, I believe, so you'll be able to check out the DOJ guidance. This DOJ guidance hasn't been archived. Yay, it still exists. Next slide. Okay, and the federal government has already been enforcing the equally effective communication requirement. They've been doing a lot on voting websites, very important. They've been doing a lot on higher education websites and apps and educational materials. They have a program called Project Civic Access where they go out to jurisdictions across the country and survey them and check their website and require all those things to be made accessible over time. And the Department of Education's Office for Civil Rights had a digital accessibility team aimed specifically at educational technologies, and they started on their own over 100 compliance reviews to review websites and educational materials at higher education and public education as well. And then they've been doing Title III enforcement, mostly against pharmacy and grocery stores that offered vaccination sites during COVID. So that was a big focus on their work then. Next slide. So there remain some legal issues that we fight about all the time. Damages. Covered entities don't take website and mobile app accessibility seriously enough, and here's the reason. Title III of the ADA does not provide for damages, so they think their liability risk is minimal. But there are statutory damages under some state laws, like New York, California, and Florida. Shockingly, you will find that most of the lawsuits happen in New York, California, and Florida. Now, Title II, state and local governments, does provide for damages, but a recent case, Cummings versus Premier Rehab Keller, you can boo, said that emotional distress damages are not available under Section 504 of the Rehabilitation Act, and every court to have addressed the question so far has said that also applies to Title II. Most of the damage that people feel when they encounter an accessibility problem is emotional distress, frustration, anger, feeling bad about yourself, depression. Those are the things that my students in higher education feel when they can't access their materials. Those are the things people feel when they run into a barrier that they can't get around. So we're thinking now in other terms. Believe me, damages are not going away under Title II. So we're saying, okay, you have feelings about this. We can't recover for your feelings, but we can recover for your educational opportunity. You were denied this class that you paid for. So let's get the money back, shall we? You were denied the ability to complete your degree on time and have a salary. Let's get that money back. And then other opportunity losses. So the opportunity, we had a case against the DC police. We have a lot of cases against the DC police. Sorry, it's a target-rich environment. We sued them because they targeted a man with schizophrenia to charge him with murder. And while he was in an active schizophrenic state, they conducted their interrogation of him. He was actually speaking to other people that were not in the room. And they interrogated with him and planted inculpatory statements on him. We said he should have been reasonably accommodated during that interview. You should have waited for mental health staff to help him. And that the opportunity to have a fair interview was his loss. And we recovered damages for him on that basis. So the opportunity that you lost is a basis for damages. We're now talking about a couple of blind jurors. I thought we had resolved this question 30 years ago, but blind jurors are being excluded from jury service. And so the opportunity to participate in jury service, which some people think is fun, is a source of damages. Okay, we're also talking about standing. So you've heard a lot, no doubt, about the many, many, many people who go to a website, test it, find it inaccessible, file a lawsuit. That's called tester standing. They may or may not be actually planning to use that website to go to that store to do that thing. They're just testing it. And tester standing has a long history, came mostly out of fair housing testing, where you couldn't tell whether a renter was refusing to rent to you because they didn't have, because you were Black, or because they actually didn't have any place to rent. So people would send in a white tester and a Black tester to see if it was racial discrimination, and it was. And that was, and people had standing to bring those cases. Standing is a technical legal issue. So that case went, the Atchison Hotels versus Laufer case went to the Supreme Court. And then Laufer and her lawyers said, we quit. So the Supreme Court did not take the case. They found it to be basically improvidently granted and moot. So that issue has not been resolved. People are still fighting over standing. But the question here is, in the standing cases, the right to information is the harm. So do you have a right to get the information from the website? And if you do, that gives you standing. If you don't have a right just to get the information, then you won't have standing. I think websites are about information. It's kind of the whole point. So being denied that information should give you standing. There's still argument about the place of public accommodation for reasons that escape me. We defined covered entities under Title III as places of public accommodation, which has raised a weird set of arguments that online only businesses don't have a place and therefore are exempt from Title III of the ADA. Now, the Ninth Circuit, which is so far the most conservative circuit on this, has said websites are covered if they have a nexus to a physical place. So online only entities are not covered in the Ninth Circuit. The 11th Circuit panel, a panel of 3 judges in the Winn-Dixie case said, well, you need more than a nexus. The inaccessibility of the website has to somehow interfere with your ability to use the place of public accommodation. But then that case was also found to be moot. They sought hearing from the entire 11th Circuit. The entire 11th Circuit vacated it, so we actually don't have anything from the 11th Circuit. And then we have some assumptions about what other circuits will do. They haven't taken this up in the website context. They've taken it up often in insurance context. So we think DC, the First Circuit, the Second Circuit, and the Seventh Circuit would say you don't need a nexus. Online only businesses are covered. We think the Third and the Sixth Circuit would go with the Ninth Circuit and say you have to have a nexus to the physical place. And the 4th, 5th, 8th, 10th are unclear, we don't know. But Minnesota, which is in the 8th District, the Minnesota District Court recently came out and said online only businesses are covered. The key here is, who cares? I talk about this a lot and I'm like, yeah, well, I can sue wherever I want. Websites are everywhere. So again, you may notice that a lot of these cases go to the DC, First, Second, or Seventh Circuit because your websites are there. You can't limit them to the Ninth Circuit or the Sixth Circuit or whatever. All right. And then there's the magic bullet of overlays. Magic bullet in quotation marks. So we've been arguing for a long time that overlays are snake oil. Someday they may be great, we don't know, but so far not so great. Often make things worse. So the Federal Trade Commission recently reached a settlement with Accessibility for misleading its customers, and they have to pay $1 million to go back to their customers, and they have to stop saying that their product makes you ADA compliant. And then those customers themselves have rights, so they filed fraud cases against a couple of the overlay providers. So we'll see how those go as well. So overlays, not necessarily an answer, and I'll talk a little bit more about that. Next slide. Okay, now putting the government aside, as we shall for the next 4 years. Private enforcement. We're not done. There are lawyers out here, and we've been busy. So according to UsableNet, 4,000 ADA website lawsuits were filed in 2024. 40% in New York and California. Why? Damages. 77% were e-commerce sites, where you're selling something online. And then in March of this year, 457 lawsuits were filed. So we are on track to have an even bigger number this year. And the Title II web reg hasn't even rolled out yet. 141 of those defendants had already been sued. This is just dumb. You got sued, you paid some money, you didn't fix the problem. So you got sued again. You'll pay some money. It's like fish in a barrel, seriously. 132 of those were using an overlay or a widget. So that's not working. And in the absence of the federal government, more and more accessibility enforcement is going to fall to private attorneys and advocates. So we'll see more litigation. The opting out of the federal government here is not a good thing for covered entities. When you deal with the government, they negotiate with you for a really long time. They provide you a ton of technical assistance, and in the end, you reach a settlement which requires you to make the changes over a fairly long period of time. You don't have to pay attorney's fees. You usually don't have to pay damages. Guess what, people? Private attorneys don't do that. We don't provide you a lot of technical assistance for free. You could pay us. We don't give you long deadlines. We give you short deadlines because you've had 30 years already. And we demand damages, and we demand our attorney's fees get paid by the entity. So covered entities should be begging the federal government to get back in this business. Very few cases go to trial for a number of reasons. Many settle after a demand letter or after a complaint is filed. Many of those settlements are confidential. I hate that, but many are. Some don't require the fixes, hence the 141 people who got sued more than once. There are some class-wide settlements. We have to watch very closely for these nationwide, class-wide settlements, because they may take away people's damages rights in California, New York, Florida, and elsewhere, and because they may rule out lawsuits for everybody without actually getting the fixes made well. So we watch those very closely. But most of the reason these things settle is because you're not going to win. Your website is in fact inaccessible. You didn't write down your defense. You can't make your defense. So it's very hard to win a dismissal early in the case. That's why there's so much fighting about standing. That's the only way to win a case at the early stages without investing. What?
So it's cheaper to fix than litigate.
It is cheaper to fix than litigate. Okay, next slide. So recent private enforcement includes not just websites and mobile apps, but inaccessible check-in kiosks. Both LabCorp and Quest got sued about their inaccessible check-in kiosks. Now, inaccessible check-in kiosks and the like are not covered by the DOJ Title II web rule, but they are covered by the existing effective communication requirements. So we already have those requirements that require kiosks and self-checkouts to be accessible. The LabCorp case is going to the Supreme Court on a question about class certification. Nothing substantive about the actual law, but on whether you can certify a class the way that this class was certified. The Quest case, the trial Jury found that Quest had violated Title III, and that the court ordered a nationwide injunction to make their kiosks accessible. And the Ninth Circuit affirmed that, and so those kiosks are being made accessible. One of our cases, Los Angeles Community College District, this is about inaccessible materials, class materials, websites, registration, orientation, on and on and on and on and on. We have now tried that twice because these things never end. The jury found that the websites, databases, and materials were inaccessible and violated Title II of the ADA, and awarded over $40,000 to the two students. But the district court, I won't make a comment, reduced the damages and issued a narrow injunction. So we are appealing that to the Ninth Circuit for the second time. But we think that was beyond the judge's power. And then just recently, we filed suit against West Virginia University on behalf of 2 blind students. And that also challenges inaccessible websites, inaccessible databases, inaccessible materials. Our students are not getting the materials that they need to participate in the group collaboration tools, to participate in their internships, to participate in their classes. And so we'll see how that goes. Next slide. So here we are now. What will happen now? So we'll continue to, some states and local governments have started to argue, well, I don't have to do anything. The Title II web rule is not in effect yet. And you'll have noticed that I keep referring to the existing effective communication obligation. Well, the courts agree with us. In Ellerby versus the state of Louisiana, Louisiana said, no, the web rule's not in effect yet. I don't have to do anything. The court said, you already have an effective communication obligation. You do have to do it. That case is not dismissed and will go on to trial. The DOJ has been talking about Title III web regulations for almost as long as it's been talking about Title II web regulations. That ain't going to happen in this administration. They don't like regulations. So we won't get more guidance on Title III. We'll be continuing to use the effective communication obligation. Some people have feared that the president might, by executive order, revoke the ADA. He can't do that. The ADA can only be changed by Congress. And you may have noticed how well Congress is working these days. The ADA Title II web regulation, people are worried that the administration may revoke that. They can do it. They can't do it by executive order. They can only do it by notice and comment rulemaking. And it'll be a hard argument, having just recently found that there was a great cost-benefit analysis that supported this rule, that this rule was needed and reasonable and proportional. Now they would have to argue that all that was wrong. And we would all comment again on how right the original rule was, and they would have to explain why we are wrong. So that would be a long, drawn-out process. We don't know if they'll pursue it, but that would be a long, drawn-out process. ADA guidance probably won't get any. Some of it may be revoked. They've already revoked, I think, 9 guidances. Weren't very important ones, so we're okay. And then the Access Board was going to come out with self-service transaction machine regulation, and that's unlikely to happen as well. Next. So what will happen now? The new administration has dismantled the offices of civil rights at all the agencies. They've been cut in half or more than in half, less than in half, whatever. They've cut more than half. But there are lawsuits challenging those because those are statutory functions. Those agencies are actually required to investigate every complete complaint they receive. And so having that requirement means you can't get rid of them so they can no longer do that job. The Civil Rights Division is being cut by some reports. 70% of the lawyers in the Civil Rights Division have left or are leaving. That is very bad. But the statute also says that the Attorney General shall investigate alleged violations and shall undertake periodic reviews of compliance of covered entities. They can't legally stop doing those jobs. They may build up a giant backlog. And as I said, the lack of enforcement from the federal government will lead to more private suits. The NFB every year for the past couple of years has introduced the website Software Software Applications Accessibility Act, which would make clear that covered entities don't have to have a physical place and would prohibit vendors from developing inaccessible websites. A lot of time we get the entity saying, I didn't do it, I paid someone to do it. And we say, well, you should sue them, but I can't sue them. This would make it so that the private person with a disability could sue them, and it would provide for damages. So we'll see how far that gets in this current Congress. There may also be movements, as there have been in the past, for a notice and cure bill, the opportunity that where the plaintiff has to write to the entity, give them time to fix the website, and then can't sue if they fix it. Next slide. Now, Section 504 of the Rehabilitation Act also plays here. This covers recipients of federal funding, and it also has the equally effective communication requirement. This covers a lot of doctors, a lot of schools, a lot of lunch programs, just way more things than you would think. And the Department of Health and Human Services issued a regulation last year saying, for websites and mobile apps, you have to meet WCAG 2.1 level AA, same exceptions as Title II. They're a different effective date, and it's based on the number of employees the entity has, and it uses the same exceptions as the DOJ Title II regulation. Again, that regulation can only be revoked by the government through another regulation saying everything we said last year was wrong. That'll be a hard argument to make. But Texas, looking at you, Texas, and a dozen other states filed suit in Texas against the Department of Health and Human Services, challenging the constitutionality of the regulation. And not just the constitutionality of the regulation, but the constitutionality of Section 504 itself. That case is currently stayed. And the states, after a lot of advocacy from the disability community, have said to the court, we didn't really mean that. We didn't really mean the whole constitutionality of the whole Section 504 and the whole regulation. We only meant a few still significant things. So we'll see where that goes. But the Department of Education was planning to put out a Section 504 regulation that would have included the web requirements, and that's not going to happen. Next slide. Now, Section 508 of the Rehabilitation Act, federal government websites, mobile apps, and other digital technologies. The GSA report shows that, sadly, less than a third of agencies' top viewed information and communication technology is fully conformant. Almost 50% of them still accept vendor deliverables without checking access. For heaven's sake. There are a couple of private suits, the Orozco case, which challenges FBI technology. The case found that there is a private right of action to sue under Section 508. The Santos case, which I'm involved in, sues the VA for facing not her, but EHR, electronic health records, and that case is ongoing. And there may be false claims cases. False claims cases are great because they give a bonus. Part of the money that the government recovers goes to the whistleblower who points out that the false claim has been made. So if entities are claiming that their technology is accessible when they sell it to the federal government and it's not true, that can be a false claims action. You can lose 3 times the amount of money you got from the federal government, and a big portion of that goes to the private individual who turned you in. Next slide. Okay, what'll happen? I don't know. What has happened so far, the accessibility statement has been removed from whitehouse.gov. That's not a good sign. The OMB memoranda that told agencies how to implement 508 and set in oversight of their implementation of 508 has been archived. So that's probably not good either. This raises the question, will we get those GSA reports anymore that I just cited? Will we know anymore what is going on with federal agency technology? And then there was the DEIA executive order, which made me feel bad about having encouraged them to add A to the DEI. They did a slight backtrack on the accessibility part in a February 5 memo from OPM, making clear that agencies should not terminate or prohibit accessibility or disability-related accommodations that were required by law. And in executing reduction in force, agencies who retain the minimum number of employees necessary to ensure agency compliance. So they did try to say, we didn't mean cut your 508 office. We didn't mean cut your 504 office. We didn't mean cut your employee disability complaints office. We don't know yet to what extent those offices have been decimated, but they have been decimated nonetheless. So that means less federal compliance. Next slide. But we may be saved by Europe. Yeah, Europe. The European Accessibility Act goes into effect June 28th of this year. Affects entities doing business in the EU, covers websites and mobile apps, hardware and software, e-commerce and services. Currently the standard is WCAG 2.1, but they're working on updating it to WCAG 2.2, and there are penalties. It's not so much damages, but penalties. They vary by country. But this is potentially a big change for entities that do business in the EU. Next slide. Ooh, I've got 2 minutes. What do we do? This is my favorite part. Next slide. I don't know. No. The laws still exist. The laws can still be enforced by private entities, so keep following the law and doing the right thing. Brag about your success and outcomes, because accessibility is good for business. It's good for everybody. Tell the disability community what you're doing, even if you're not done yet. It encourages us to be patient. It encourages us to pat you on the back for doing the right thing. It discourages us from suing you because I'm probably not going to get anything more than they're already doing, right? Okay, pay attention to the cases. Stay informed. Highlight Lainey Feingold, lflegal.com, the Safe Earth Shaw blog, and my own Inclusivity Strategic Consulting blog, which I do once in a while. Don't expect something every week. And then advocate with your states and localities. States have a big opportunity now to really step up and strengthen their own laws and mandate that their own their own technology be accessible. This is a golden opportunity for states to take the lead. Now, I wanted to do just one more thing. I have 20 lessons. I've been reading a lot, reading a lot. One of the things that happened just since I created this PowerPoint was that the White House issued an executive order on disparate impact discrimination, basically saying they will no longer enforce discrimination that's based on disparate impact as opposed to disparate treatment. Now, what disparate impact means is the literacy tests that they used to enforce on voting. That had a disparate impact on Black voters who were not allowed to learn to read. That was intentional discrimination disguised as a neutral rule. That's what disparate impact means. The federal government is no longer going to enforce disparate impact discrimination. What does that mean for disability discrimination? We don't know. But if they take that and apply it to disability discrimination, we're in big trouble because most disability discrimination is just an oversight. It's a neutral rule that just doesn't happen to accommodate people with disabilities. Effective communication is an affirmative obligation. You can violate it just by not thinking. Reasonable modification is an affirmative obligation. You can violate it just by not thinking. Physical access is an affirmative obligation. All those are disparate impact discrimination methods that are clearly illegal, but is the federal government going to take this disparate impact ban and apply it to disability? We don't know. And then I've been reading a lot about what to do in these days. And I've been reading on tyranny, which is terrifying. 20 lessons from the 20th century. I've only got four for you today. And I'm only 1 minute over. So the first one is don't obey in advance. Don't try to assume you know what they're going to want. These laws are still on the books and enforceable. Just because the federal government doesn't play in this field anymore doesn't mean we don't keep going. This is the right thing to do. Okay, 2, remember your professional ethics. This is important. You have ethical obligations to raise these issues with your clients and your companies. This is part of our obligation as humans and professionals. 3, be as courageous as you can. You don't have to go all the way, but do what's as courageous as you can manage. Step out there, put your neck out a little bit. My neck's all the way out. I got a big bullseye on me. And then stand out, stand up, brag about what you're doing, be proud of what you're doing. I'm proud of what you're doing. And thank you all so much for doing it. And thank you for listening to me today.